China was claiming when it occupied certain islands or rocks that they were also entitled to exclusive economic zones of 200 miles, which were completely invalidated by the ruling.
That is not correct. You are not telling us the correct answer, Mr. Secretary. Did the arbitral ruling invalidate the possession, the territorial claims of China in those features?
Exclusive right of the Philippines, and that is why we feel our rights should be respected. And in terms of the exploitation of the resources within the 200 nautical miles of the EEZ.
Mr. Chair, the answers are not comforting. He does not understand the question. In the context of the South China Sea arbitration, is our territorial sea an exclusive economic zone part of our territory?
Your Honor, we consider the exclusive economic zone as well within our sovereign rights. And in accordance with...
No, I'm not talking about sovereign rights. I'm asking you about territory.
Well,
Is our territorial sea an exclusive economic zone? It's about territory.
well, in a strict legal sense, the exclusive economic zone would not be part of our territory, but we exercise the rights of exploitation, which in effect makes it, we consider it part of our territory.
Medyo may problema tayo sa sagot mo, Mr. Secretary. What strict legal sense?
The strict legal sense is within 12 miles, but in terms of the actual...
No, the territorial sea is 12 miles away from our shoreline. 12 nautical miles. Exclusive economic zone is 200 nautical miles. But under public international law, these features, these seas, are not the territory of the state. That is the correct answer. I'm asking you this because you made a statement after we were appointed Secretary of the Foreign Affairs that you will uphold the landmark ruling which found most of the claims of China invalid and that the findings are conclusive. That was your declaration. Tell us the claims of China, Mr. Secretary, that were invalidated by the arbitral ruling.
Yes, Your Honor. Well, the main claim of China, which was invalidated, was the 9-dash line,
Yes,
where China basically claimed all...
that's the one. What others? Because you said the various claims of China in the South China Sea.
Well, China was claiming when it occupied certain islands or rocks that they were also entitled to exclusive economic zones of 200 miles, which were completely invalidated by the ruling.
That is not correct. You are not telling us the correct answer, Mr. Secretary. The arbitral ruling did not invalidate the territorial claims of China in the Spratlys. You know that there are 100 features in the Spratlys. And the only parameter and the only decisions made by the arbitral ruling are only 8 of those features. Do you know that, Mr. Secretary?
Your Honor, I think what the ruling did was it definitely said that, for example, artificial islands or islands which were, let's say, rocks, only rocks, but not islands, were not entitled to any...
That is correct, Mr. Secretary. I'm asking you, did the arbitral decision confined itself to 8 features of this Spratlys only, despite the fact that it has or it consists of 100, more than 100 features. At sinabi doon, Mr. Secretary, the maritime zones. Sinabi lang yan, if it is a rock. Meaning, a rock, not an island. Because an island will entitle itself to 200 nautical miles. And there are islands occupied by China there. Pagka rock, it is only entitled to 12 nautical miles. Kapag ito low tide, wala siyang entitlement. High tide, meron siyang 12. The question is, did the arbitral ruling invalidate the possession, the territorial claims of China in those features? That is the question.
Well, the ruling itself did not address the claims.
Hindi nyo validate, Mr. Secretary. Diretsuhin natin, that is the problem. Because there is a limited jurisdiction of the Hague Arbitral Court. Wala siyang jurisdiction or territories. Jurisdiction niya per the position of the Philippines is only to consider a declaration whether or not the 9-dash line is consistent. Because that is the only position we made. We did not ask for anything. That's why the order did not provide any. Halimbawa, nandun ang China, ang kanyang territory. In public international law, territory is also ownership. Yung nandun, and therefore it enjoys the maritime zone entitled to those occupied territories. Meron siyang economic zone, 200 miles. Meron iba doon territorial sea, 12 nautical miles. And these areas collide with our own exclusive economic zone. Yun ang problematic eh. Make public statement, it is as if you're claiming high hopes for our country. There are claims there that were not invalidated by the ruling. Kakulang natin is a declaration, the 9-dash line is invalid. Yun lang. China is miles. But we are in possession of these islands. Hindi ba, Mr. Secretary? Hindi na gusto natin ipaalam sa tao eh. Pero sinabi mo, doon sa isang declaration mo, during the 6th anniversary of the arbitral award, you said that this arbitral award in the South China Sea and the includes the twin anchors of the Philippine position and action in the West Philippine Sea. Do you know that?
What we mean is, or what I meant, and it was that we will follow, first of all, the UNCLOS, which is the basic rule on the maritime law, and that therefore there are many aspects to the UNCLOS which we feel should be the basis for the way countries behave. For example, in South China Sea, freedom of navigation.
Mr. Secretary, ang ginawa lang ng arbitral award is a declaration that the 9-dash line is inconsistent with the clause because China was unable to prove that basically those lines were supported by historic rights. Tama naman ang arbitral award. Ang China doon, walang historic rights that would define those 9-dash lines. The problem is, hindi naman inalis ang kanilang territorial. Sila pa din ang may-ari ng mga isla na nasasakupan ng ating economic zone. So, hindi masyadong naiintindihan ng ating mga mamamayan. As I had told you last time, hindi ba dapat ang kinonsider ninyo, which is another factor of the, or another provision of the UNCLOS, because South China Sea is a semi-enclosed sea. What do you understand about a semi-enclosed sea within the meaning of the UNCLOS, Mr. Secretary? So this is very important.
Well, within the meaning of UNCLOS, there, as I said, there is the freedom of navigation entitled.
No. What is the significance of the fact that the South China Sea is semi-enclosed sea in relation to obligations of coastal states?
Well, from the perspective of the Philippines, the way we would look at it is that because of the UNCLOS, we are entitled to the exclusive economic zone, which stretches to 200 nautical miles within the semi-enclosed sea, the South China Sea. And that is the right, exclusive right of the Philippines, and that is why we feel our rights should be respected. And in terms of the exploitation of the resources within the 200 nautical miles of the EEZ.
Mr. Chair, the answers are not comforting. He does not understand the question.
May we know from Congressman Marcoleta what answer is he trying to secure from the good secretary, or if the good secretary does not understand the question, perhaps
Yes, sir. Because
he will not get.
he made a declaration that the UNCLOS and the award are the twin anchors of the Philippine position and action in the West Philippine Sea. So that we would like to know from him, what do we expect to do from there? Because if he understood that the South China Sea is a semi-enclosed sea, then he would understand that from there, he could already take actions like, because a semi-enclosed sea is defined under 123 of the UNCLOS. Dito po sinasabi na kapag ka semi-enclosed sea, all the coastal states together, coordination, management, exploitation, exploration, and even exploitation of the resources, both living and non-living resources. At pwede ba natin explore doon, Mr. Chair, traditional fishing rights, where we can protect our fishermen. Wala akong nakikita ganito yung isasagot niya. Pinipilit niya yung jurisdiction natin. Sinasabi nga natin, nanalo tayo in so far as the declaration that the 9-dash line do not exist. Itinapon niyo ng arbitral award. Sabi nila, walang basis yan. You cannot claim historic rights and even sovereign jurisdiction on maritime rights. Natatawalan ang China sa atin, Mr. Chair, because it has nothing to do with their possession. Their arbitral ruling did not eject China possessing and occupying these territories, particularly these patlies. This is the problem, Mr. Secretary. That is why we would like you to see, to explore the very issues why we're fighting for yung rights natin. Sana tingnan mo yung bilateral na lang, doon mo ikutin ngayon yun. Because sa paragraph 805 or 806 nung arbitral award, makikita mo doon, Scarborough Shoal was even defined by arbitral award as a traditional fishing ground. And from there, we can convince China, just like what it did with Vietnam in 2000, in the Gulf of Tonkin, they had a fishing agreement. If Vietnam was able to do that, the Philippines can also do that. That's the case, Mr. Chair.
Chairman, perhaps we can, if the implication here is that unfamiliarity is dangerous, perhaps we can secure an answer from the good secretary with the permission of Congressman Marcoleta. Sagot po. Tama po yung tanong relevant po yung tanong ni Congressman Marcoleta.
Yes. So in fact, it's a little bit clearer now. Yes, the award, for example, in terms of the Scarborough Shoal, sinabi nga na it respected traditional fishing rights, and that in fact is part of one of the essential elements. And I think ganun din when it comes to the when I mentioned our sovereign rights in terms of the economic zone, yes, that is what we're trying to protect. Yung mga fishermen, for example, our fishermen, when they try and exploit the resources of that area or whatever other resources are available, yun ang those are the things that we wish to protect or at least assert our rights on. So it's in that respect na we feel that the arbitral award made it very clear on those certain points, and therefore we are obligated to see how we can protect it. Now, if other countries seek to prevent us from exploiting our rights, that's where we have to then challenge their attempts to deprive us of our rights. So in that sense, that's how we would view the implementation of the award. Kaya nga I said it was really an essential part of our approach to the South China Sea. Ngayon, how do we defend it? We, for example, talk with the countries who are trying to deprive us of those rights. And we do have regular talks with them. In addition to the to other methods, for example, in regional fora or international fora. So it's exactly those rights which were expressly contained in the arbitral award and UNCLOS that we're trying to defend.
Wala doon sa arbitral award yun, Mr. Secretary. As a matter of fact, we were expecting you to, for example, cite cases in 1974, if you know that. Yung dalawang fishing jurisdiction cases between the Federal Republic of Germany versus Iceland, UK versus Iceland, sinabi doon, the coastal state may have preferential rights on this, but they cannot exclude the rights of other fishermen from Germany and UK. Dapat gano'n ang approach natin. Sabihin mo sa amin yun, the cases, for example, in the bilateral award between Eritrea and Yemen in 1988. Sinabi doon, even the case of sovereignty is not inimical, but rather entails support the facing ground in that region. Ito dapat, eh, but we are not expecting any, pinipilit mo, umikot to. Kaya nga na, we're leading you to all this because this is supposed to be the direction that you will take in relation to the public statements that you made. But because we thought that you are ready to do all this, but sorry to know that you were headed to other directions. We were trying to put you in the direction that we should take. That's all, Mr. Chair.